All right, could I see the parties on Shalise Schnitz?
Morning, Your Honor.
Good morning. Where's your client?
Coming.
I don't know why people approach without their clients. They have to be a part of this. And if you all could spread out, she's in the center. All right, what is happening with this case?
Your Honor, we've made a request for blood discovery. I think that's an order that needs to be signed still.
Has the order been filed? Has the motion been filed?
I believe so, yes.
Has the motion been filed on blood discovery? Let me see. All right. State, have you had a chance to review?
Judge, I spoke with defense briefly. I did say we weren't going to be in agreement on the motion for blood discovery.
Yes.
Oh, yes, we're in agreement with that. Yes.
Okay.
I think we're just waiting for it to be signed
Okay. And what are you not in agreement with?
on modifying the bond conditions. Your Honor, defense has filed the motion.
We filed a motion, Your Honor, to modify the bond conditions, but we can get that set for a hearing.
All right. What are you requesting with modification?
So Ms. Schnitz is currently on full GPS. She's being monitored by Scram and by her ignition interlock. We're just asking for a curfew of 8 p.m. so that she'd be allowed to drop off her daughters at school and pick them up and go to work. So all we're asking is from 7 to 8 p.m. She'd be allowed to be on tracking only and then come home. But she is being monitored by Scram. She's being monitored by the ignition interlock. She's also on the drug patch and being required to do urinalysis. If we could waive the urinalysis and just have her do the drug patch, this is extremely costly to her. That would help us out also.
All right. So we'll set that for a hearing. But Norma, on this case, can you recall it in 45 days and just put it at discovery?
And Judge, sorry, if I may, can I get a copy of that blood discovery motion so I can make a copy in the back so I can send it
Sure.
out?
Sure. I'm sorry, what day? And then they want a hearing on a bond motion modification.
I just need the motion and then I'll set it once I receive it.
All right. So she'll give you a reset form for September 21st. Is there anything else?
Nothing further, Your Honor.
All right. Once you sign that, she's excused.
Thank you.
You're
Thank you,
welcome.
Judge.
Good morning.
She's coming. Your Honor, we have,
Where's your client?
she's coming. So, Your Honor,
All right. Court is calling 2023 CR 5651, State of Texas versus Shalise Schnitz. Can I have parties announced for the record for the state?
Jason Garahan, Your Honor.
Defense?
Shannon Locke for Shalise Schnitz.
And are you Ms. Schnitz?
Yes, ma'am.
All right. The court is in receipt of a motion to modify full house arrest. State, have you had a chance to review the motion?
Previously, we did, yes.
All right. Are you in agreement with the motion?
No, we're not, Your Honor.
All right. Defense, do you have any witnesses?
I do, Your Honor. I have, so we're really asking for two things. We're asking that she be allowed to pick up and drop off her children from school. And then additionally, we're asking that she be allowed to participate in outpatient alcohol treatment. We have the outpatient alcohol treatment provider here. We'd like to call him as a witness if we could.
Okay. All right. You can call whatever witness you'd like to call. All right. Can you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, I do.
All right. You can lower your hand, state your name for the record.
My name is Richard Paul Green III.
All right. Defense?
Tell us a little bit about yourself. What do you do for a living?
I am a licensed therapist specializing in chemical dependency counseling. I'm the CEO of Precision Recovery in San
All right.
Antonio.
And just not to interrupt, but I'm aware of who the gentleman is. So if you want to
Can you
move past that, you
Sure.
can. If not, state if you want him to go into his credentials, you can.
That's all right.
All right.
Thank you, Your Honor. Can you describe the program, just briefly what we're here for?
Sure.
Ms. Schnitz is on full house arrest, and I'm asking, really, what we're all asking is how can she participate, or what kind of supervision does she need to participate in your program? And can you describe the program to the court that she has signed up for?
Yes, I can do so. Ms. Schmitz has voluntarily entered the Precision Recovery long-term treatment and monitoring program, specifically for felony DWI defendants. It's a long-term medically integrated program. which lasts 3 to 5 years. She will start with an intensive outpatient level of care, possibly partial hospitalization level of care, and then move through the program where she will see a professional at least at a minimum of once a week for the next 3 to 5 years.
Is this something that she can do? So is it more effective to be in person for those meetings or remote?
We do like to see our patients in person. We find it to be much more accurate. The monitoring part of the program is very intense. It's built on the modeled after the physician's help program and the airline pilot's HIMSS program. So it's a very high level of monitoring, and we really need to see people in person.
If the court made participating in your program a condition of bond, and Ms. Schnitz were to not complete the program, stop going, or begin using substances that were prohibited, would you be able to report that to pretrial and to the court?
We could and would report that to the court.
And what kind of monitoring can you provide in addition to right now she's on scram and she's on the ignition interlock device?
So we would add to that LCMS urine drug screens weekly, randomly. We would also add a heart rate variability monitor to be worn 24/7. That shows us when there's issues with heart rate variability that the client or patient is under stress and maybe at risk of relapse. She would be on remote treatment monitoring, where we'd have our call center ready to call her. They would contact her 3 times a month regardless, but in case there's any issue. We'd be using a medical compliance device called by JerrySafe called MediTrust. That machine videotapes her compliance with her medication. She's already been prescribed naltrexone. When she's on the right therapeutic dose for naltrexone, and we'll be measuring that through laboratory tests to make sure it's at the right level. She won't get any reinforcing effects from alcohol if she did relapse on alcohol, and it will blunt the reinforcing effects of other substances as well. We'll be using a recovery app that is designed for the therapeutic courts, called Reconnect, where we can tell where she is 24/7. We can geofence her out of areas should the court or her treatment team decide to do so. We also can know whether she's attending her AA meetings, which is very important. We really strongly recommend she be present to an AA meeting at least twice a week. We can tell whether she's on time, whether she left early, and whether she's contacting people in her support group, including her Alcoholics Anonymous sponsor. That's just some of the monitoring we do. There's more than that, including outcome testing regularly.
And so could you just describe for the court what she needs to leave her house to participate in?
So she would need to leave her house to participate in Thursday night groups where we can run urinalysis weekly and check in for outcomes and for other signs and symptoms of any type of issue that would lead towards relapse, any, for lack of a better term, disruption in emotional sobriety. Beginning September 18th, the plan is to bring her into a partial hospitalization group where she would be at our clinic from 9 a.m. till 5 p.m. So she needs some travel time in there. So probably from 8:30 at least till 6. Then after that, she'll be at a level of care of intensive outpatient, where we'll be seeing her Monday, Wednesday, and Thursday from 6 p.m. to 9 p.m. for 12 weeks. After that, we'll be seeing her on Mondays and Thursdays from 6 p.m. to 7:30 p.m. in what's called supportive outpatient. She will be have physician appointments with our physician, with our addiction medicine physician too. That schedule I don't know at this time. He would like to see her at least one time in person, and the rest can probably be handled through video.
And can you provide these schedules to Ms. Schnitz, who could then provide them to pretrial in advance?
Yes, absolutely.
I have no further questions. I'll pass it.
So this program is, what type of substance is the person addicted to?
They can be addicted to anything. Most of our patients have alcohol use disorder.
So they have to admit they have an alcohol dependency, particularly in this case.
Admit.
Yeah.
Well, yes, they come around to it eventually.
Okay.
Yeah, there's
denial.
denial is usually there.
Yeah, I'm not trying to get into all the clinical things.
Yeah, yeah.
But I mean, this program is, especially in this particular case of this client of yours, it's an alcohol dependency that she has.
We don't use the term dependency anymore. We say alcohol use disorder.
Okay. I mean, change the name, but it's the same thing, right?
Yeah.
Okay. And in this particular case, so do y'all make reports? What do y'all do? Do y'all make written findings?
We can do whatever the court would like. Usually for pretrial, we provide what that pretrial officer wants. Same thing with probation.
So if, I mean, anything's discussed, it can be in a report that's sent to the judge.
Yes, anything that's relevant to the public safety or the compliance of the patient with the program.
Okay. No further questions.
Nothing further, Your Honor.
All right, I have a question. Any objections to the court asking questions?
No objection from the state, Your Honor.
No objection, Your Honor.
So you're able to do these meetings by Zoom?
We do have the capability. We'd rather not do anything other than medical follow-ups through Zoom. We definitely would like to have the first medical assessment in person. There's just certain things we need to be able to do, like palpitate the liver, et cetera, and look for physiological issues that are actually hands-on. We'd prefer to see all our patients in person. We've used Zoom in the past, and it's our belief that in person is much more effective.
All right. So the only thing that you may not be able to use, well, you do not use Zoom for, is for medical testing.
We cannot use Zoom for medical testing.
Okay.
Or laboratory testing.
I just wanted to
Yeah.
make sure.
Yeah, we can't. We have not found a way to use laboratory testing or urine drug screens or quantitative EEGs. Many different medical interventions we cannot use remotely.
Okay. All right. Any other questions?
Just to follow up, Alcoholics Anonymous in a remote setting, is it as effective in a remote setting as it is in person?
In my opinion, no. It really takes being there, being in the moment, and sitting with people who can relate to who you are. But Alcoholics Anonymous is very important for treatment. And there was a great meta-analysis that was published in 2020 that shows that it may be the only thing that maintains long-term sobriety. And I can provide that study for the court if you'd like to see.
I've read it. Yeah.
Thank you.
Yes.
I appreciate that.
I always try to keep up on all things treatment and anything really to do with the legal system. Thank you.
I really appreciate that.
Oh, you're welcome. I try. All right. Thank you. Is there anything else?
Your Honor, just argument, I suppose.
All right. Thank you.
Thank you.
I would like to ask your client a couple of questions. Is there any objection?
Well, Your Honor,
Because there are things that I need to know.
okay.
And if I don't know them,
I understand.
then,
I understand. I guess we'll see what the question.
all right. Can you raise your right hand for me?
Yes.
Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth? So help you God?
Yes, ma'am.
All right. You can lower your hand. State your name for the record.
Shelley Schnitz,
All right. How many children do you have?
3.
What are their ages?
I have a 22-year-old son with severe special needs, quadriplegic. I have a 15-year-old daughter, and I have a 6-year-old daughter.
All right. So who helps you with your children?
Patrick, who is my boyfriend. We've known each other for the past 10 years. He helps me. My family helps me. My mother and father, as well as some other supports.
Are they all here in Bear County?
No,
All right. So who's here in Bear County that helps you?
Patrick.
Okay. And what are the school hours for the 6-year-old? Does the 6-year-old take the bus or no?
No, ma'am. We live exactly 1 mile from the school, which is Wilderness Oak Elementary. And so we cannot obtain the bus permission for her to ride the bus because we're too close. So she has to be taken to school every morning Drop off is between 7 and the tardy bell rings by 7:25. And then pickup is in the afternoon. The bell rings at 2:45 to start pickup. And then it just depends on how many cars and things are there to go through the line.
All right. And your 15-year-old, does the 15-year-old take the bus?
No, ma'am, she's at Reagan High School.
Mhm.
And she, their time is 8:30 to 9 to get to school. And the time that she gets out is 4:30 to 5.
So you do drop off with her?
Yes, I have split custody with her father, and we do that.
So if I were to allow you to do this thing at the clinic, how are you planning on taking the 15-year-old to school? Because the person testified that it's from 8:30 to 8:30 a.m. to 6 p.m. So who's going to be taking the 9-year-old? I'm sorry, the 15-year-old,
I
if I were to allow that.
I can make arrangements on the special days, Your Honor.
And Your Honor,
No. Still asking questions. So what would be your arrangements for the 15-year-old during that time?
I would probably ask one of the moms that's a friend of hers that has a child that goes to that school that I'm friends with, or something like that, just on a very short-term situation.
All right. Any other questions?
Help you say, John.
you also take her early.
Oh, yes, sir. I'm sorry. I didn't think of that. Yes, sir. I absolutely could do that.
Usually if you can get, you can get them anytime after 8,
Oh, sure. Yes. Yes.
and that would allow you enough time to.
Yes, I'm sorry. Yes.
All right. Anything else from either side?
Nothing from the state.
All right. The court will hear argument.
Your Honor, we're hoping that you allow her to drop off and pick up her kids from school, obviously. I think the court's investigated that. I think it's.
All right. So let's stop right there. State, do you have any objection with her being able to drop off her children?
Your Honor, just the severity of the allegations in the indictment, it's I believe a 14 count indictment of intoxicated manslaughter, intoxicated assault, aggravated assault, failure to stop an underage, causing to death, and failure to stop an underage, causing injury. The state would just be opposed to her driving it out.
Okay. And are you currently, well, I'm assuming she's currently driving.
No, ma'am.
She's on full house arrest, Your Honor. So to do the urinalysis, for example.
Well, no. So if she's on full house arrest, then we were here last time where the court allowed her to attend parenting night. How did she do that?
Because we got specific.
No, we got permission, but how did she get to parenting?
Oh, Patrick was able to take me because it was after his work hours.
Okay. All
But,
right.
I'm sorry.
No, go ahead.
Do you mind if I say one more thing?
No.
Because of his work hours, he has a position at Southwest Research, which is entirely across town from our home and area. And he goes in early and he works later. So he could not manage to not be late to drop her off or not be late to work and also to pick her up because of his time involvement with work and the consideration with traffic and him driving across town. So that would leave me as the option to take and pick up.
All right. State, do you have any objections with her going if she's not driving?
No.
All right. That's what B is for.
There would be no way to take a bus. There's no bus in my area.
Mhm.
The school is 1 mile from my house.
Mhm.
And also, Your Honor, I have not been driving for over 5.5 months.
Mhm.
I have been to 30 days of full inpatient rehabilitation, which I was very successful at.
That's 30 days.
But Your Honor, I'm sorry.
No,
Okay.
you can
Then I
continue.
also did a 12-week intensive outpatient program as well. And I have been perfectly I have not had any issues after that with any testing, with anything else in that time, Your Honor. And I am very committed to my sobriety and staying clean and doing the right thing, Your Honor. That is the most important thing, and my family. And if I have to pay for transportation currently on an Uber or a Lyft, because I do not have any family or anyone else that may take me. And Your Honor, that is costing me $900 a month. And Your Honor, I have come to the limits of my financial situation. I have no retirement. I have no savings. But I'm trying very hard, but financially, I cannot afford that. I'm sorry. Thank you.
No, there's no need to apologize. I want to hear what your circumstances are so I can make an informed decision. I always tell people, if there is something I'm saying, but you want to respond to it, please respond to it, because if you're quiet, guess what? I don't know. So I appreciate you telling me what your financial circumstances are. Okay. All right. Anything else from the defense of the state?
Your Honor, as far as the treatment goes, I do think that it's important that you go in person. I will tell you, Your Honor, being on full house arrest with sole custody of a child, she's probably one of the loneliest people that you will see in your court. Being a part of a group of Alcoholics Anonymous is going to be a tremendous help to her. Being part of a recovery community that was described by Mr. Green is also going to be a tremendous help to her. So we would ask that she be allowed to do those things in person as part of her recovery and pretrial release.
All right. So it's the court's understanding, and correct me if I'm wrong, State, you have no objections with her attending treatment, no objections with her doing drop-off, but you do not want her driving.
That's correct, Judge.
All right. So the court will allow you to attend all the treatment. The court will allow you to drop off and pick up your children, but you are not allowed to drive. Is there anything else?
Nothing to state.
Can we, Your Honor, then get the ignition interlock device removed from her vehicle, because she's going to have to give up. Right now she
It
has
to go back.
All right. If you file the motion, the court will hear it.
a separate hearing on that, Your Honor.
Pardon?
A separate hearing on
Yes.
that.
So I'll allow you to attend all medical appointments, all treatment appointments, all school functions. And I consider, when I say school function, I consider dropping your children off to school, picking your children up, going to their extracurricular activities. So all school functions, but there's to be no driving.
Your Honor, may I ask one question?
Sure.
May I walk to school?
Yes. Yes, you can walk,
Or ride a bike?
just no driving. State, do you have any objection to her riding a bicycle?
I can just walk. I don't have to ride a
No objection
bicycle.
to a bike, just as long as she's following the traffic law, John.
Okay. All right. Is there anything else?
Nothing further, Your Honor.
All right. Thank you.
Thank you. May we be excused?
Yes. You're welcome. All right. Shalice Schnitz.
Good morning, Your Honor.
Good morning. So where are we on this case?
Well, first, we don't consent to appearing on YouTube,
All right. That motion is denied. Where are we on this case?
but I would like to make a record, Judge, about having to appear on YouTube.
All right. Where are we on this case with regards to discovery?
So you won't let me make that record, Your Honor?
The motion will be heard when you file your notice for pretrial motions to be heard. Right now, where we are is there's a motion for blood discovery. There was an agreed order. Where are we on that?
Judge, the blood discovery was provided to defense. They provided it electronically. We sent the link to files, I'd say a few weeks ago. Defense has access to those files through those links for about a year.
All right. So is there any other outstanding discovery?
Defense did bring to my attention through email earlier this morning, 2 or 3 items that I did not have the chance to fully check the electronic discovery to see if they were in there. It's statements from witnesses that were taken at the scene. There's a lot of discovery here, so I couldn't say whether or not we've already provided it. If I get a short amount of time, I couldn't verify that.
All right, Ms. Ferguson, on this case, give me a 30-day reset for discovery, please. This will be the final discovery date, and we'll hear motions on that date.
Your Honor, there's also a outstanding motion to modify conditions of bond. Ms. Schnitz, and this is one of the reasons we don't want to be appearing on YouTube. Ms. Schnitz has been ordered by the court not to drive. She has a vehicle in her driveway that is being in the process of being repossessed. Obviously, these are very personal matters. She's also in a child custody dispute with the father of her children, and he is using these videos in her.
All right, Ms. Ferguson, can I have a 30-day reset? At that time, the court will hear your motions. And at that time, that's the last time the court will have this set for any outstanding discovery. So you all need to confer and you all need to make sure that you have all of your discovery.
Yes, Judge.
Can we get the ignition interlock device removed from her vehicle?
I will have the discovery hearing and I will have the motions hearing in 30 days. Everybody needs to be prepared for motions.
And if the car gets repossessed before then, Judge?
All right. What date, Ms. Ferguson? All right, October 26th.
Thank you,
Okay.
Judge.
Thank you. Court is calling 2023 CR 5651, State of Texas versus Shalise Schnitz. Am I pronouncing your last name correctly? All right. Could I have parties announced for the record for the state?
Daniel Escobar with the state of Texas.
Defense
Shannon Locke for Shalise Schnitz.
and,
It's Mr. Javier Garcia.
all right, is he on the case as well?
Yes.
All right, you want to announce for the record?
Javier Garcia, Your Honor.
All right, so I have several motions before me. The first is the motion for defense to conduct an independent analysis of the defendant's blood sample. Did y'all review that?
So we took a look. My understanding of that motion is that defense wants to get the second vial of blood taken by BCSO in this case and send it through their own lab. I mean, the state has no objection. I think that's something that they have the right to do.
Okay. All right, that will be granted. And of course, the laboratory here will have to make safeguards, and that's not in the court's purview to make safeguards for the analysis.
Right, Judge. My understanding is that the defense will have to, whoever is analyzing the blood for them will have to pick up the blood from BCSO, and there will have to be a clear chain of custody. So that's something that they're going to have to do.
That's correct, Your
Sure
Honor.
that the safeguards are in place.
Judge, sorry. Quiet, please, in the courtroom.
All right, everyone, you need to whisper. All right, and then the motion to expect, examine, and test physical evidence.
My understanding, Judge, is that the defense wanted in that motion to take a look and inspect the vehicles that were involved in this case. My understanding is that they are in the Bexar County, they're in Bexar County's possession. So that's something that we can try and facilitate. It's just coordinating everything with everyone. I know that the detective in order for us to inspect, he has to be there.
All right, so do y'all still want to keep number one where it says that you are to produce the vehicles? Because I don't know if that's the proper wording.
Just make available to us for inspection, Your Honor.
All right, if y'all want to put in there to make available for inspection instead of produce.
We don't know. Okay.
This initial, Your Honor, that's
Yes.
Mr. Escobar's handwriting.
Initial fee, Judge. Here you go.
All right, thank you. All right, that will be granted. And then there's a request for no broadcasting. Is that correct?
That is correct.
All right. So the court has read the defense's motion, and what I can tell the defense is, number one, the court limits the number of people in the courtroom for security reasons, also for health reasons. I think everybody is aware of the brawl, for want of a better word, brawl, skirmish, or whatever that occurred in the other courtroom. As everybody is aware, there are only a limited number of deputies. I have 2 deputies in this courtroom, and we almost had another incident here today that I think would have turned quite differently if the courtroom were packed. The court must have an open courtroom to the public, and that is how the courtroom is keeping it open to the public. So I read your motion, and that motion is denied.
Your Honor, may I make a little bit of a record on that?
Sure.
Okay. And so Ms. Schnitz has some specific things that have affected her as a result of the broadcast over YouTube. And specifically, Your Honor, the open courts, one, we don't think that you need to close the courtroom to non-participants. So we object to the closing of the courtroom, which we were just made aware of this morning. So we have that objection. We think the courtroom should be open to live audience members. Ms. Schnitz is in a very particular situation. She's in a custody battle at the time, currently, and her ex-husband monitors these YouTube videos. He saves them and broadcasts her information to her friends and family and uses it in her child custody case. Additionally, Your Honor, sorry, I'm going to have Ms. Schnitz speak to that if she could.
Sure. Can you raise your right hand for me, please? Do you solemnly swear affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes,
All right, you can lower your hand, state your name for the record.
Shelley Schnitz.
All right, thank you. You may question.
Are you concerned about being broadcast on YouTube?
Yes, I'm very concerned.
And can you tell the court why?
I'm very concerned because my ex-husband, the husband of my daughter, who is,
I'm sorry, the father of your daughter?
the father, I'm sorry, has been, he is being investigated currently for abuse of her sexual assault and numerous counts, a very, very serious situation. And he is using the YouTube videos, and he's explained that in emails to watch what is happening on court to find the location of my daughter. And I'm sorry.
So also, he would come in person before, correct?
Yes, sir.
Okay. And now he knows where you are because he can watch the broadcast. Is that right?
Yes, ma'am.
Oh.
Yes, sir.
Okay. And when you additionally, you've had to talk about your treatment situation. You're addressing your alcohol issue. We've had to do that in open court previously. Is that right?
Yes, sir.
And has he recorded those to your knowledge?
Yes, he records those as well.
And he lets other people know who are involved in your case?
Yes, he lets over 20 people know and places it on social media and sends it out.
Okay. And that's everywhere from Governor Abbott to Joe Gonzalez to everybody that is also the principal of your daughter's school. Is that right?
Yes, sir.
Okay. And so at this point, you're left with a choice of either terminating these proceedings by entering a guilty plea or continuing to be broadcast on YouTube.
Yes,
Okay. And that's the choice that you're currently facing. Is that right?
yes.
Okay. All right. Do you want to be broadcast on YouTube?
No, sir. It's very scary for me. Terrifying.
No, that's all right. I have no further
Any
questions.
questions?
Nothing to say, Judge.
All right, and the court will state again, everyone is aware of the brawl, skirmish, whatever you want to call it, that took place in this courthouse recently. No less than, I think, 10 deputies or maybe more were summoned. There was a fight in the jury box where audience members came from the audience and attacked someone, and I will use the word allegedly, but I think everybody is aware of it, an inmate that was in the box. We just had what could have been a bad incident in this court today where deputies had to step in and escort somebody out of this courtroom. This is a court that needs to be open to the public. I am not going to allow people in the courtroom for safety reasons. I'm not allowing people in the courtroom unless they are a defendant, a person accused, or unless they are a witness. And those witnesses will be brought in when they are needed. The state will tell you, and other persons in this courtroom will tell you, anyone who is given victim impact, they can come in when it's time for them to give victim impact. But that is the way this courtroom will be run. So for security issues, we only have two deputies in a courtroom, and we have a third, I'm sorry, sort of a third, and I say third because he's wearing his jacket, right? But he's not assigned to this courtroom. So when you think about it, right now we have 1, 2, 3, 4, 5 people in the box. And really normally only two deputies. And sometimes we have 10 people in the box. So the motion is denied. And we're going to come back
And Your Honor,
on December 12th.
just one other question. Could you admonish people not to record the broadcast?
Oh, people, I am not in charge of broadcasting.
So what happens is people will capture, like they'll capture this event, they'll put it on other platforms.
And what I can tell you, counsel, is in this courtroom with your client, I have never asked, nobody's ever asked, if I'm wrong, tell me I'm wrong. Nobody's ever asked what school her child is at or asked any of that nature. With regard to a civil case, that's something that needs to be addressed civilly. This is a criminal court.
But what happens, Your Honor, and the problem is that this is now, the YouTube broadcast is as much an official record as the court reporters.
No, it's not. The court reporter's record is the official record. I made my ruling. You all are coming back on December 12th. On December 12th, I expect everyone to have their discovery in order. If there's more time that's needed to look at a vehicle, let the court know. If there's some issues with the blood, let the court know before the December 12th setting. All right, Ernest Morales.
Thank you, Your Honor. Can we be excused?
Yes, you may be excused after you sign the reset form.
Thank you very much.
All right. So the issue is blood. Is that correct?
Yes, Your Honor. So
Let me see if I can find that. So where is the blood located?
Judge, it's with BCSO. It was in the receipt from the lab was in the blood discovery we previously tendered to defense.
Okay. So what steps are you taking to get this completed?
So we've found the lab that can do it, Your Honor. They can retest the blood. So they're going to, I suppose, I need to get a contact person over at BCSO to send the FedEx envelope over to them.
All right. Do you have a contact person for them?
No, Judge. We never really play a role here at this point.
All right. So you need to call them today to get a contact information for them to get that done.
And then once that happens, Your Honor, it'll be 30 days.
All right. So I have your motion, but there's no order attached.
There's not an order attached?
No.
I can get you an order.
All right. So besides that, is there any other outstanding discovery?
The one thing I'm checking on, Judge, so I did notice recently when looking through the file that there was a Cellubrite report, and at least that was there. When I tried opening it, it didn't work. I reached out to BCSO to see what was happening there. I just emailed today just because we were here on this case. That could be the only thing that I could think of that's outstanding.
All right. Anything else outstanding?
Not to my knowledge, Your Honor, but I would like to know more. I wasn't aware there was a Cellubrite report that was outstanding.
And Judge, what it says is in Bear Pick, it just says Cellubrite report. When you try and open it, it just doesn't open. So I don't know if it's just wrong case, if this is the right one, if there was a report done. I just don't know.
All right. Your last discovery date is going to be in January. After that, this is either going to trial or either it's going to be a plea. Does everybody understand?
Yes, Your Honor.
Judge.
All right. Ms. Ferguson. I'll put this at the end of January for final discovery. And state, have you already tendered an offer?
Yes, Judge.
All right. So this date is going to be your plea deadline date as well.
I can do the 30th.
All right, January 30th. That will be your plea deadline date. And also that will be the final date for discovery. All right. Is there anything else?
Your Honor, we would ask that you reconsider the motion to prohibit the YouTube broadcast.
Oh, yes, I've already done that. And no, I'm not reconsidering. All right. So January 30th. And counsel, you have an order. Is that correct? For me?
For the blood discovery?
Yes.
Okay. Can I bring that by this morning?
I'm sorry?
Can I bring that by to you this morning?
Yes.
Thank you.
Okay. I don't know why. Sometimes the order is just, I don't know if you filed an order with it, but there's no order attached and it just doesn't print out. All right. So once you sign the reset form, you will be excused.
Thank you, Your Honor.
All right. Thank you.
Let's get the facts straight. She loves a verbal ashtray. Never blowing smoke when she gets pissed. She's quick to castrate. Love her on a good day, love her on a bad day. Either way, she's here to stay, stay, stay. Holy, 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 holy,